lecture should be here. All right, so this is just an important topic, relatively simple, but if you don't know about this, it's very important. You have to prepare a report at the end of your forensic investigation. This is why this class is not as good for a real professional forensic investigator as it ought to be. I know there are other kind of classes I've heard where you actually have a courtroom set up and you practice testifying in court and you practice making a real report and all that. And we may get there in a future version. This version I focus more on instant response, but now we got some money to buy in case and other software. So next time I teach this class, it may be in a case certification class. Anyway, but one in a thing that was directly focused for the expert witness side of this, which this class has not been, you would all be faking these reports to practice. Although I think in practice, we are not that much a law enforcement crowd, not that many of you are going to go in the world of being expert witnesses, but it is important to know. An expert witness is a special person in court who has the ability, like there are mythical figures that could turn lead into gold. And an expert witness can turn opinion into evidence. Normally, no one's opinion matters in court. The only thing that matters is facts and direct testimony of what they saw. And if they say they heard somebody say they saw something, that doesn't count because it's hearsay. And if they have some opinion about something, that doesn't count because who cares about their opinion? We just want the facts. But an expert witness is the person with the special power to state opinions, and they count as evidence. And in order to gain that power, they have to go through investigation by the court where you are allowed to ask them about the qualifications. And the expert witnesses I know have resumes that are like 40 pages thick, full of every paper they wrote and every conference they talked at. And you have to be a recognized leader in your field. And you have to be so impressive that people are willing to believe that when you say, in my opinion, it was this way, they'll listen to you. And this is where you can answer questions you will always hear, like, if somebody is accused of doing something illegal on your computer, you examine the hard drive, you find it, and they'll say, well, couldn't a virus have put that there? Not my person accused of it. And the expert witness I know would say, in my experience, I have never seen any virus that would put stuff like that on there. Now, of course, mathematically, it would be possible to write a virus to put any kind of data on the machine. So you can't say it's impossible, but if you're a credible expert, you can say, it's not a virus that put it there. I can tell that's not very likely, and what's much more likely is that the perp really did the bad thing to put that evidence there. And that's what you need. So anyway, so even if you're not an expert witness, you have to file a report. Even investigators who are not expert witnesses can write reports, but those reports should include only facts. The expert witness can also include opinions. All right, so you may have legal or policy requirements that require you to end your investigation and file a report. If you are a regulated industry, like an investment firm or a medical firm, you will have to be answering to government agencies about your incidents, and they will want to see some report showing you investigated the incident and decided important things like how many people's data was lost and what did you do about it and all that. All right, anyway, in general, it's a good policy to write a report whenever you have an incident. It's expensive to have instant response. You spend a bunch of company time and money doing it, and you're going to lose all those lessons if you don't have a summary at the end of what were the lessons we learned, what were the facts we found, so that when we have future incidents, we can refer to that report and use it to guide our planning. So that's the point here. There are times when you should not write a report. The main thing is if you write something down, unless you can market attorney-client work product, it is discoverable. And if you get sued about this in the future, you will have to submit that report as evidence to the other side. And this has gotten a lot of people in trouble. There's one I've heard, Yahoo. Yahoo got breached, and a whole bunch of data came out, and then there are a bunch of people that said they actually knew 2 years before that they had been hacked and didn't do anything about it. And if there was some kind of internal memo from somebody saying, I found this evidence, I think we got breached, that was flying around, that might cost Yahoo a lot of money if that comes out. So there are conditions under which you are told not to write things down by your client, and for legal reasons. And in that case, you would not write it down, but you have only a verbal report for certain things. And I must say, if I were to be in a case like that, I would probably want to consult my personal lawyer to make sure that I'm not getting in some kind of trouble here, because that's beginning to worry me when I'm supposed to hide things. I want to make sure that I'm not getting culpable for somehow participating in some kind of cover-up that's going to get us in trouble later. But anyway, there are cases when you do it. Another thing is, if you have an interim report before it's all done, mark it draft. If you publish some report and you don't mark it draft, and then later on you have a revised version that changes things, they can bring them both up and say, why did you lie? You appear to have covered something up. You appear to be incompetent, and you don't want that. So make sure everything is marked draft until you have the final version. And after you have the final version, you better be confident that you're not going to have to revise anything you said in there. If you do, you're going to have an explanation of why did you think you were sure and then find out that you were wrong. So the report is supposed to be focused. You have questions. There's a reason you did the investigation. You had questions to answer. Typically, what did the attacker steal? How did they get in? How can we kick them out? That sort of thing. So you should have questions and answers easily found. People should not have to hunt through the report and dig for things. The important questions should be right there, clearly stated, clearly answered. And there's an executive summary at the start. Microsoft Incident Reports are a good place to start. There's an executive summary that does not get into any complicated details or have any code or anything. It just says, here's what the problem is, here's what we found. We thought someone had intruded on the system. We found that in fact they did intrude, they stole 5,000 records, and then we kicked them out. They should find that information. All right. You stick to the facts. Don't say anything vague or subjective. Make sure you've double-checked everything. You are legally liable for the statements you're making. It is your reputation. If you have opinions to state, clearly state that this is my opinion. This is not a fact. And you should make sure your report comes out quickly. You should be developing the report while you're doing the investigation, not starting at the end. That's the way you get it result quickly, and you also make sure everything is accurate while it's still fresh in your mind. So anything you put in here should be reproducible. This is something I'm very used to. I used to be a scientific researcher, and this is the standard deal. The point of a scientific research paper is it has a motivation section and a conclusion section which say why you did something, why this is interesting, and what you found, and why it's exciting, and in between it has all the details so another person in your field can reproduce exactly what you did, everything they have to know to do what you did. And that would be the other side. The other side, your plaintiff, the defense side wants to do it, and the defense and prosecution, the two sides both have to do it. The other forensic investigator should find in your report enough information to look at the image and totally find the same results. And so you have to include enough data to do that. If you had to do something unusual to find the files, like you had to piece them together from slack space or dig through them or translate from one format to another, that should be in there so the other investigator can reproduce your findings. All right, everything should be focused and concise and above all accurate. You just answer the questions in as few words as possible. If you've seen TV shows about lawyers, they have this thing. You ask a question, you give them an answer, and then you don't ramble on. You just give the answer and stop. You should write in an active voice. The attacker stole the data. It's easier for people to read and understand than this passive voice. There is a tradition in bureaucratic documents to write things that are difficult to read for no good reason, just to make it seem, to intimidate you, to make you think that they must be smarter than me. That's why I can't understand this. And that is not the point of this report. So this is easy to read. The attacker stole the data. It's hard to read. The data was stolen by the attacker. It's just a clumsy way to write, and it's you should choose the first one. That's called active voice. This is called passive voice, and it's a classic error in fiction writing. If you want people to understand you, you don't write in passive voice. Everything is in past tense. You're not talking about the future, so everything did happen in the past. The attacker came in on this date. I found this file on this date. I took this evidence on this date, and so on. Use short sentences, and don't use vague terms like numerous or several or many. If you should know the exact number, and you should quote the exact number of everything you're doing. You are the investigator. You know how many files you found, how many days went by before something happened, and so on. You say what you did. Don't bother saying what you tried to do and couldn't do unless you have to. If you say what you failed to do, you sound like someone incompetent. So if you have to say that something did not work, you have to give a reason. Like the operating system reused the deleted file space, making the deleted file unrecoverable. That makes it clear what happened, and it doesn't say, I tried to do it, but I couldn't figure out how, so I gave up. You don't want to say a thing like that. All right. And you should have this general policy. You say what you're about to say, then you explain it, and then you summarize what you said. This is generally how you communicate with people, so that people, this is what they do in news articles. You can read the first paragraph, and then you can leave, because the first paragraph summarizes what's going to happen, and now you know whether you care or not. And if you care, then you read the rest, and then there's a review at the end to remind you of the points. This is the standard way of communicating if you want to get through to people. You should understand and cooperate with the fact that almost everyone who reads your report will not read the whole thing. They will just look at the first paragraph for a couple of sections, find what they care about, and then pass it on. The only person who's going to dig all the way through it is the opposing forensic expert, who will dig through the whole thing. The rest of them just want just the executive summary. What did you find? Does it matter? All right. If you're going to use acronyms, and you almost certainly are in this business, like NTFS and MBR and registry keys and all that jazz, then the first time you use them, you have to spell them out. Make sure you're getting them right. An enormous number of people in this field, I've even seen plenty of textbooks do this, they have the wrong spelling out for acronyms. They don't actually look things up. I always get really mad at textbook writers that do this, because students refer to textbooks and you shouldn't have your reference materials wrong, but they often are. So make sure you go and Google it and make sure that you're right about how things spell out. Don't use jargon, use clear words. Exfiltrate is technical, instant response jargon. Data theft is something people can understand. Compromised is vague. What does that mean? You have to say something very clear. The attacker gained control of this server, the attacker stole this, the attacker found this password, not that it was compromised, because that doesn't tell me which one of those things happened. All right, so use some consistent form of naming. If you're going to refer to each thing as a system or as a host or a node, that's fine, but pick one and stick with it. Don't use informal language, not slang like check something out, examined. You are going to go to court. I got hurt by this one when I was a brand new working at Masco Agency, and I was doing forensics, although I didn't really know it. But anyway, I was doing an analysis of data, and I had this database that was a problem, and I tried fixing it one way, it didn't work. I tried fixing it another way, it didn't work. I had all these tests, and one point I wrote on this thing, phooey, because I tried the 4 tests and it didn't work. And I didn't know it, but that page went to court. And then the boss asked me, what does this say here? And I said, it says phooey. And he gave me this look, the kind of look that makes you remember, I'm not going to do that again. So I didn't know anything I was doing was going to go to court. I was the junior guy. I had no idea, but they don't like hearing things like that when someone's in court and it's going to be the end of their company and people are going to go to prison and you're writing down stuff like phooey. They feel like you aren't giving proper seriousness to their suffering. And I was far away from that, unaware of these considerations. So that's how you learn. Anyway, so if you have opinions, you have to state them clearly, make it clear their opinions, and then say why. In my opinion, a virus did not write this because I have investigated hundreds of similar things, and I've investigated a lot of viruses and malware, and I've never seen any malware that writes anything like this. But I have frequently seen people doing things on their computer in their browser that leaves traces like this, so it is clear to me that it is far more likely that the perp actually used their browser to create these files than that some virus put there. That's what you'd say. All right, now like I say, that's an expert witness. An expert witness is inspected to meet a certain standard of credibility, and then if the jury believes the expert witness is credible, they can now state opinions, and those opinions count as evidence. But most examiners are not expert witnesses. It is a specialty, and you pretty much have to be a recognized, prominent leader in your field and specialize in this activity. All right, so if you are an examiner and you're not an expert witness and you need to have opinions in court, you may have to subcontract and hire a consultant who really is an expert witness. They charge a lot of money, they vary greatly in quality, and on it goes. There are not enough expert witnesses at all. It is a very lucrative profession if you get in it. But you do have to get a nice thick resume that will really impress people and convince them that they should believe what you say. All right. Formatting standards, of course, you want this thing to look good in court. It doesn't really matter what font you use, although it shouldn't be something ridiculous like Comic Sans. It should be something standard and boring like Times or Arial, and you should just keep things consistent. Don't use ambiguous dates like 555 because Europeans put the day first and Americans put the month first, and so you don't really know what it means. So what they recommend is January 28, 2012. Everybody knows what that means, and that's the point. It doesn't need to use the minimum number of characters. It needs to be clear so that everybody knows what you're talking about. And your book says don't use local time, which is a wise plan if your investigations are going to cover a large area. Use GMT for everything, UTC for everything, and 24-hour use ET in addition, not so you don't have this AM and PM stuff. That would be probably a good plan for large investigations for multinational corporations. Yeah.
And in military time, I assume?
Yeah, military time, 24-hour, yeah. Same thing. If you really want to write something down and you're considering something big. I mean, I tend to think of small cases where it's all in California, and then I suppose you could use California time, but in real world, UTC is wiser because not only do you have time zones, you also have daylight savings time going by. If your investigation crosses a few months, and in general, if you just want to be really sure you know what time it is, it should be UTC. All right, so you should have some standard way of writing things down, like the file name, the timestamps, the path, the MD5, and every time you refer to a file, you should have exactly the same data in the same order. So it just becomes consistent. Otherwise, you look sloppy and people can't find what they need. You should have references to the things in your file. Microsoft Word has the ability to put in references and footnotes and captions, and it can create an index that automatically points to them, and these are features you should use to make a professional document. So tables and figures are important. You need them. Be consistent so they all look good with fonts, borders, and shading. Put in captions, reference the captions in the narrative. If you have a figure 2, you should have a sentence somewhere that says figure 2 shows this. All right. And you should have templates ready for your reports. There's the overall incident report, and there are subsections of it that will be analysis and malware analysis reports inside there. So you got to have a title page and a table of contents, just like a book, because people are going to be referring to this. On page 7 in Appendix 3, you said this, and the opposing examiner has something to say about that. They think you got it wrong or something. Your report may be privileged and confidential. This is up to your legal conditions of your investigation, but it might very well be a confidential report that doesn't go too far. So you have a background section that says how you discovered the incident and what you're trying to accomplish here and what happened. Then you have a findings section, which states the goals, like the executive summary, in a very simple way. And then you have recommendations. There are short-term recommendations and long-term recommendations. As we talked about a couple of classes ago, there are short-term things you do right away to deal with the current problem, and there are long-term recommendations to improve the security posture of the company over the next years so that this sort of problem doesn't come back again. And in the middle, you've got these individual analysis reports, where you've a summary of them, and then you have the reports themselves, which will be full reports like forensic examination of a machine, live response of a machine, malware analysis, and all that'll be the actual data, which is the foundation for all the conclusions you're stating elsewhere. And nobody will look at that except the opposing forensic examiner, most likely, but it has to be there so that anybody that has a question, did you really prove this, can go there and see exactly what is your evidence to justify this statement and decide whether they believe it or not. And then you have appendices. This is where you have the output of your forensic tools, long listings of file names and binary printouts and images and whatever else you've got, long lists of all the facts you found that justify everything else. So an analysis report has got pretty much the same kind of structure: title page, table of contents, background, the evidence you examined, timelines, details, and again, appendices with the complicated technical stuff that no one's going to look at except the opposing examiner. Then, this is a very good policy. When I worked in the escrow agency, there was a fundamental rule: nothing ever went to a client that had not been examined by 2 people. Everything had to pass 2 pairs of eyes. This is a very good principle, and they recommend it, Mandia it too. So you prepare your report, and then somebody who did not help make that report has to read through it and criticize it. This is really important because if you work on something, you get blind to parts of it. You get parts of it are boring, parts of it are not your field, you skip over it, so something can be wrong and you won't even see it. Same thing's true of writing code. You need a separate set of eyes to look at it and find out, wait, this part seems to contradict this part is sloppy, this part seems to be missing. It'll be much better if it passes through 2 sets of eyes on the way out. Another issue is if you're using Microsoft Office or other advanced tools, there's a serious problem with these tools. There are metadata leaks. If you make a document by starting with another document, which you're probably doing like a template, and then modifying it, you might be leaving metadata from the previous document. It might have the name of a previous case for a previous client. You open the previous client's report, you make a copy of it, you delete all the contents, replace them, but the metadata, like the owner and the date it was formed, are still referring to the wrong client. This is embarrassing, and it could even get you in legal trouble. So it's an issue, and there's a whole link here of how to clean metadata out of Microsoft Office documents, because it turned out it created a lot of embarrassments. About 6 years ago, it was a big scandal when people found this out, and you could be in business negotiations, and someone could send you a Microsoft Office bid, and if you went through the metadata, you would find that another team actually wanted to offer more money, and this team said, oh no, offer them less, and you can see stuff like that the person who wrote the document didn't intend for you to see. There were some published government documents that included confidential things that had been incorrectly erased, so they were still in the document, they were just not visible, obviously. So that's a big issue, and that's all I wanted to tell you about that. I think I'm going to hand it over to Tom. Let me stop this recording, and Tom, do you want to record your thing? Okay, so this is 121, chapter 16 or something